Good morning, everyone. I'm Margaret Hinkle. I chair the Post Commission. Let me call to order our 38th public meeting. Members of the public, we are grateful for your attendance at this meeting. And let me at this time establish which members of the commission in attendance. Commissioner Bluestone? Are you here?
I'm here. Good morning.
Mr. Calderon. Mr. Calderon is here. Commissioner Ellison.
Present.
Mr. Kazarosian.
Present.
Mr. Luma.
Good morning, President.
Commissioner West.
Good morning, present.
And Commissioner Wynn.
President, good morning.
We have a quorum. And with that, I will ask for a motion to approve the minutes of our May 11th, 2023 meeting.
So moved.
Is there a second to that motion?
Second.
Any questions or comments? If not, let me ask for a vote. Commissioner Bluestone,
I approve.
Commissioner Calderon,
Can't hear, I'm sorry, I can't hear Commissioner Calderon, even though he's not muted, it doesn't appear for some reason.
would you raise your hand, Larry, if you approve the minutes? Thank you very much. He approves. Commissioner Ellison,
Yes.
Commissioner Kazarosian. You
Yes.
move. Commissioner Luma,
Yes.
Commissioner West,
Yes.
Commissioner Wynn.
Yes,
Thank you. I also approve. And with that, let me turn next, please, to the Executive Director report. I turn to our Executive Director, Enrique Zuniga.
Thank you, Madam Chair, and good morning, Madam Chair and Commissioners. We have been very busy over the last month on a number of initiatives that you're all familiar with. I'm going to share my screen and walk you through the Executive Director report. Can people hear me okay? There seems to be some feedback intermittently. Anyway, it seems to have gone. Okay, so let me share my screen if you give me just 1 minute. Can everybody see this PowerPoint? Okay, so I will be going through a certification update, the progress we've made over the last month, and a topic of policy discussion relative to collecting officer information. All of those materials are included in the packet. I'll also provide a disciplinary records update. And as is customary, I'll also turn over some portion of this report to Eric Rebello-Pradas, who will give us a budget update. We're only 16 days away from the deadline to submit the recertification information that's required on all officers whose last name is between I through P. The staff has been working very hard to offer support, grant access, and troubleshoot emerging issues. There are not many, but there's a lot that has to be done in this effort. I'm happy to report that the portal is working as intended, and we have turned our focus for a few weeks now on communicating and ensuring that agencies submit the information prior to the deadline. Again, that is only a short 2 weeks away. We want to make sure that officers are all certified and can be processed in a timely manner. So as of last Friday, these are some of the metrics that we have received. There are a number of user logins that have been assigned. Those are 735. There's at least 525 users who've used the portal once, at least, or more. There's 435 agencies that we expect to hear from. Those are the agencies in scope, and that there's 345 of them have requested access. We continue to communicate with those other 90 agencies to make sure that they have access to the portal, that they know that of the deadline, and they're aware, and they're taking all the steps necessary to complete this process. I will note that this does not mean the 90 agencies that have not had any interaction with the portal does not mean that they have not taken steps to complete the certification process, but it does mean that because access to the portal is really the first time where we can see agencies making progress. But again, we continue to communicate with those agencies to ensure that that they know that they need to interact with that portal. I see a question from Commissioner Luma.
I just wanted to know, we see your presentation view. I don't know if you want to change that.
Okay. You mean you see two screens that are separate?
If it's not an issue for you, that's fine. I just wanted to make sure you know that.
Yeah, thank you. It is something that I don't know how to track at this time, how to change. But thank you. Okay, let me move on to the continue on the certification update. There are these are more detailed numbers from what I was reporting in the previous slide. The majority of agencies have interacted with the portal, but they also have yet to submit information, and we expect that they will do that in the coming days. The majority of the agencies know of the deadline, and we continue to communicate that this information is critical to be submitted prior to the deadline, or that agencies request an extension as our regulations provide. So broadly, about 48 agencies are actually, 48% of agencies have reported information to us. That translates to about 23% of officers. And what that effectively means is that the small agencies have already, most small agencies have already entered information that is required. And what is pending is agencies, understandably, agencies with a lot more officers to enter and process in the portal. Included in your packets, commissioners, is also a memo that is broadly summarized here from me, and a letter from one of the unions relative to concerns they have on information we're collecting as part of this process. We have the policy question for you here that we have today is, should post reconsider the approach of collecting officer personal information or require agencies to serve notices? And I will provide some background. Again, that's included in the memo. We have had some challenges in the past, not many, but important to make sure we could improve. Whether in the past as to reaching officers directly, which is our intention this time around when it comes to certain notices that come from post. The guidance that we've issued is this time around is that officers both confirm the work email and provide one of two addresses: a personal email address or a physical address. The physical address does not need to be a home address. It just needs to be a physical address. This new requirement of post gave rise to some concerns about public disclosure of this information or unauthorized access to this information. We've clarified that we know officer home addresses and personal email addresses are not a public record, and we will not disclose them even if they are in our possession. But still, there's concern about again some unauthorized access, for example, and this is information that officers, are appropriately so concern about disclosure. We've also taken important steps on safeguarding this information that I could get into if you're interested, but it's mostly around segregating data and ensuring that there's not one place where would-be hackers could access this information. We also ultimately believe that it's in the officer's interest to have this information, for post to have this information on file, so that we can communicate directly to officers. Now, still, there's a letter in the packet that raises those concerns. They're not dissimilar from conversations we've had with another union, and we believe this ultimately turns into whether whether post requires agencies to place whether post places the burden of serving officers of some notices from post, whether we place them on the agencies, or whether the agencies have the option to serve those notices. Let me pause there and see if commissioners have questions about or concerns about reconsidering our approach or further clarifying our approach. Can everybody see? I stopped sharing, right?
Yes.
Is there do any commissioners have questions or would like to weigh in on the topic of sharing information? Requesting information from officers.
Enrique, if I could just ask you to clarify the very last thing you said, you're not suggesting you are suggesting a universal policy, correct? Not a policy depending on the individual agency?
Well, what we have given, what our guidance is that agencies submit information one of two addresses: a personal email address or a physical address. What one of the unions has said is it's okay, they understand that's a good option to have, but the question is, if an officer wants to enter the address, the work address, meaning the agency address, that effectively means that the agency would be required to serve the officer in that instance of a post notification, as opposed to as it being optional for agencies. Would it be required of agencies if the officer so chooses? This is a very nuanced difference, but they would want us to change the current approach, which is to give agencies the option, agencies and officers, the option to enter either of those two addresses. Is that still not clear, Commissioner Calderon?
Thanks, Executive Director. I'm unaware of what union that would be that's requesting that documents be sent to their organization. The organizations that I've been in contact with, excuse me, that have discussed this topic, I believe are recommending the email version as opposed to officers' private, personal, residential addresses, or that of their union institution, which would then, as you just said, it would be in, excuse me, I'm not sure which one of you just said it, but it would be incumbent upon the union then to make sure that those documents are delivered. That is quite troublesome because officers retire, they change their addresses. Sometimes even the unions don't know where their members may be residing or have changed. So we're taking the position that a new email address dedicated to the post commission and any documents be created and adhered to. So I'm unaware of that situation, but it sounds troubling to put the union in a position where they would be required to make sure that something was delivered.
Fair enough, and that's exactly what we believe our guidance allows for, the flexibility of officers to and agencies to enter either an email address, one that they can create solely for this purpose, with an auto forwarding to any other email address, for example, or a
That
physical
was
address.
my understanding.
Yeah, or a physical address, which could be, the any physical address, a PO box. The only requirement is that, and I should have mentioned this in my remarks, regardless of what they enter, if they enter one or the other, when post gets confirmation of delivery to that address, we would make that confirmation that they were properly notified, so that then they can make a choice. People can make a choice as to what to enter. There's in the letter in the packet, one union says officers should enter, post should require officers to allow to enter the work email address. But again, that places the burden of serving the notice on the agencies, which they may or may not want to have. And that's the crux of the difference between, our approach about being optional on those two addresses. Commissioner Bluestone, I think you wanted to.
Yes, thanks. I don't think this is what is being said, but I'm thinking about the issue of having physical addresses of law enforcement officers in one database, and just the concern that I would have as a professional if, despite the efforts to ensure that the database is secure. So I'm in favor of finding other ways to ensure communication rather than having physical addresses in our database.
Thank you, Commissioner Wynn.
Thank you. I'd been thinking about this a lot since we received the materials, and I think I had landed kind of with Commissioner Calderon that a dedicated email address was best, but I hadn't seen any objection to letting the headquarters address be used if the department was going to serve. But I hadn't thought about what Commissioner Calderon just raised, which is an officer that is resigned or retired and there's a break in service, because then the agency is not going to be able to find them. I know particularly when I've disciplined somebody or they've resigned or been terminated, we never find them again. So I think we need to put some responsibility on the individual.
Thank you, Commissioner Luma.
That was going to be my sentiment as well. I think we need to ensure or require that if there are changes in email addresses or addresses, physical address, then the officer needs to update it so that we have the opportunity to notify if necessary. I just don't see how that can be the responsibility of the agency.
Thank you, Commissioners. I seem to be hearing no change in policy, given what we currently have, that effectively allows agencies to allow officers to enter one or other information. And if they want to or don't or agree, they could enter the agency address, but that would be up to the agency. Okay, so let me continue sharing my screen to continue with my report. Can everybody see this? I think I'm going to keep it out of presentation mode so that you just see what I see, which is the slide.
Enrique, I'm sorry, before you start, if you just uncheck use presenter view, it'll be fine and you can show the slideshow. It's right to the right under automatic. You'll see use presenter view. You can uncheck it underneath. Yep. And you should be good.
Okay, thank you. So, thank you very much. Okay, so we addressed that question. Okay, just another update on the disciplinary records. We have approximately 4,292 sustained disciplinary records. They have been validated. We have still 416 instances of errors, but which is a big improvement from the last time I reported to you on this matter. We had about 1,000, north of 1,200 of those records with errors. These are instances of errors, meaning that there's a smaller amount of records with some errors, and we believe that we're within days of really completing that validation. So we are effectively in a position to soon publish the information in the coming days. We will generate a report and anticipate that, of course, there will be updates to this database once we make it public, and we'll qualify that that information may be updated from time to time in case there were still, after all these validation efforts, there were things that need to be corrected. But we are generally feeling good about the progress that we've made to date on all these validation efforts, and are prepared to publish this information within the next couple of weeks. I owed you that update from the last time we discussed this, which again, we left it open as to providing this information until there have been more validation, and I'm happy to report that we're comfortable with the way that this validation has gone. And tremendous effort by one particular staff member who's worked really hard on this topic, but others as well. Okay, let me turn it over to Eric Rebello-Pradas to just provide a few updates on finance. I can continue sharing my screen, Eric, if that's okay?
Yes, if you wouldn't mind. Yes, that'll work out perfectly. Thank you. So I think folks would remember that back in February, we actually voted on, the commission voted on the budget numbers that we were going to use for FY24, our proposal that we were sending to A&F and the governor's office, and that was a total of 9.1 million for FY24. And of course, this is just going back, just so folks have a quick history, just a recap here. May recall that when the governor's budget did come out, it was a lot less than what we had requested, and we had copped that up to possible oversight or what have you. So we had to make some vast changes within our spending plan for FY24. But of course, due to we had some great, very successful meetings with the legislature, with the House Ways and Means Chair and the Senate Ways and Means Chair. Larry Ellison and Enrique had joined in on those conversations. And sure enough, the legislature heard us and got us to 8.5 million, you may recall. And that was enough that we found that an acceptable number. It was sustainable. We had enough there to put together a solid budget for FY24. What I wanted to update you on, though, is that with some unspent funding that's we are predicting will be left over in FY23, and according to the budget language that's currently in the FY24 conference committee that they're reviewing right now, it looks like that those unspent funds will be moved forward or balanced forward to FY24. If that happens, and right now we're predicting that unspent balance or PAC, prior appropriation continued, we're predicting that to be about $850,000. So if we only took 644,000 of that, that would get us right back to where we started with our original request of 9.1 million. So it's amazing. We actually have gone full circle here with our request, and now we're going to end back with the number that we originally started with. So I think that we're in very, very good shape. I don't see any reason that the conference committee, which is currently negotiating the final budget, would make any changes. I mean, it is very possible they can do that. But right now, the only differences between the House and Senate budgets is very, very minor technical language. And then past experience, usually they don't deviate too much from that. So I think we'll actually be in good shape for FY24. Next slide, please. Just going back to FY23. Oh, and by the way, the previous slide that we were just looking at, in your packets, commissioners, there actually is a chart that's blown up. It actually gives all the detail, walking you from the original 9.1 million to the House 1 number to the 8.5 million, then back right up to the 9.1 again. So if you have any questions on that, I'd be happy to follow up. Looking into FY23, the current fiscal year, which will be ending in 2 weeks, we are predicting that our final year spending will probably be around 7.1 million. This includes the $2.9 million that we had set aside for IT infrastructure, also the Salesforce development that we have been putting together. So that 2.9 million, you may recall, was actually balanced forward or brought forward from FY22. So that plus the $5 million we had set for FY23 gave us about 7.9 million total for the year. Again, we are still predicting that we'll probably have somewhere around $850,000 in reversions, or what I should say is unspent monies that will balance forward to FY24. Looking for our hiring, we did think that we had predicting for several months now that we were going to have 31 employees by the end of FY23 or June 30th. We thought that we possibly could get another 2 or 3 possibly on top of that, but that did not materialize. So we are definitely going to be at 31 by the end of the month. We just recently hired 2 more compliance agents. That'll bring us now to a total of 4 once they're fully onboarded. And we did secure a budget and financial operations manager who will be joining us in July. We also recently onboarded we also hired 3 interns for the summer, legal interns, which will be working for the legal division. Right now, we do have posted a data analyst position currently. This is going to help tremendously with reporting, technical reporting for the Division of Police certification, that unit. And we also are still currently looking for an enforcement counsel. We actually are still interviewing at this time. And this would be a 3rd enforcement counsel for the Division of Police Standards. Now, of course, I just wanted to mention lastly that seeing that this budget was put together, FY24 budget, we built this last winter. So, around November and December of last year. So, of course, a lot of things are going to change from then until now. So, of course, once the budget is passed, hopefully it'll be relatively soon, June or July. Once the budget is passed, what we're going to do is reassess staffing needs, as well as some other resources that we might need to move around. Because again, a lot of time has expired since we had put, or has happened since we had put this budget together initially. So there will be changes. So we're meeting with the different division heads to determine if there's any staffing changes in terms of some positions might need to be repurposed into other positions or moved to other divisions or what have you. So right now we are still predicting 41 staffers for FY24, or seeing that at the end of FY24, we will have 41, which will be another 10 from what we have now. But of course, that could change. But if it does, and when it does, we certainly will bring that before you in the coming months once the FY24 budget has been passed. Yes, Madam Chair.
Thank you very much for that report, and Enrique as well. And I'm not sure whether my question is directed to you or to Enrique or to Randy, but you mentioned 3 legal interns that have been retained for the summer. Can you just provide us with a little bit of background as to where they come from?
Sure, absolutely. Randy, I certainly can speak to that. 2 of them, which were just onboarded, 2 of them are coming from UMass, University of Massachusetts School of Law. And the other one, which has not been onboarded yet, he's been hired, but not onboarded, which will be in another couple of weeks. He will be coming from the Boston University Law School.
Thank you.
Of course.
I'll take it over for this next slide. Eric, if that's okay, you
Yes,
were-
of course. Yes, of
were-
course. Mhm.
I just have one more slide in our report, commissioners, and that is just by way of update. We had a discussion with the MPTC, and they suggested, and we gladly agreed to be part of a 2-hour virtual training as part of the next training year of 2024. And by that, I mean, we will be in a position to present 2 hours in virtual training and different modules to all officers as part of their in-service training, all officers in the Commonwealth. Our thinking is that we can give an overview of police reform, the law, the requirements, the certification process, our disciplinary process, etc. We feel that this is a unique opportunity to communicate to all officers directly. There's planned production with videos, the way that MPTC does a lot of their virtual training. And we have discussions internally. There's a lot of materials that we've had in the past where we made presentations publicly, but we're updating all of that with all of our activities to date, especially as they affect police officers, to again just give information about us and perhaps demystify what may be understandings around out there. I think that concludes our report. I'm happy to take any questions from commissioners. Commissioner Ellison?
Yeah, thank you. First, I just wanted to say, as the treasurer for the board, I want to thank you guys for keeping me informed in real time, and your physical responsibility and the cost savings that you have saved the taxpayers, your team, Eric and Enrique, onboarding of the legal team has been a huge cost savings for the commission, as well as interjecting in there some of the shortfalls that we may have, i.e. with staffing who may be limited at times. You guys have already projected that in there, that some folks may have to stop working because of their hours of previous state time, but you guys have already compensated for that. So I just want to commend you guys on the work that you've done to make sure that we can continue to do the work on behalf of the commission.
Thank you, Commissioner Ellison.
Thank you.
And thank you for your work as a treasurer. It's been also very helpful for us as well.
We do look forward to your insight that you provide when we do have those one-on-one meetings where we go over all the numbers and so forth. And you always offer incredible insight. We do appreciate that. Thank you.
No, thank you. It's a very good working relationship, and I appreciate it. Thank you.
Even when we don't have coffee in the office.
Exactly.
I think that concludes our report, Madam Chair.
And let me share the accolades for the quality of the work that you and the staff have been doing, as demonstrated in the reports that you've provided to us. Let me turn now to a legal update and to our General Counsel, Randall Ravitz.
Thank you very much. I will aim to share my screen and show a PowerPoint. Okay, can you now see the PowerPoint?
Yes.
Great. This is a presentation concerning a draft, what is entitled Guidance to Law Enforcement Agencies and Prosecuting Offices regarding 555 CMR 1 and 555 CMR 6. So 555 CMR 1 is the set of commission regulations that deal with the agency handling of complaints, as well as the post-commission's own adjudicatory processes concerning allegations of misconduct by officers. But this guidance would really concern the first part, namely the agency's handling of complaints, and only to some extent deal with the commission's own handling of complaints. And 555 CMR 6 that's the post commission's regulations dealing with uses of force. Now, the goals in developing this guidance were to address questions and suggestions from inside and outside the commission regarding these topics, to provide some clarification and to fill in some details regarding provisions that are already in these regulations, but without creating any new obligations, to define some terms and concepts that are referred to in those regulations and that have prompted questions. And some of the definitions that have been offered in this guidance that have been suggested are based on definitions found in other sources. So for example, dictionaries or judicial opinions. And another goal was to call attention to how provisions found in different statutes and sets of regulations work in conjunction with each other and impact each other. So in other words, advising people, when you apply this particular provision that you see in section 1, you need to also consult this other provision that's found elsewhere to fully understand how it operates. So here are subjects that are addressed in this draft. And again, I do use the term draft because, as I'll be saying at the end, we are inviting comment from within the commission and outside the commission on this guidance, and expect to come back to the commission with a revised version. But here are the subjects that are a draft that are addressed. One is how law enforcement agencies handle complaints regarding officer misconduct. So one of the things that it says is that an agency is not in receipt of a complaint before the agency itself receives it. So in other words, if some other part of that municipality's government receives it, that's not the same as the agency receiving it. So the clock doesn't start ticking against the agency while it's in transit. A credible report, because the regulations define a complaint as being a credible report. A credible report is one that's capable of belief by a reasonable person, and that's not just based on speculation or conjecture. And again, that's an area where that's drawn from other definitions of what is credible. The 2 business day period for an agency to report a complaint to the commission in certain cases does not elapse while the agency is determining whether it's credible and therefore whether it's a complaint, as long as that period of time is reasonable. And agencies are encouraged to provide explanations if they take more than a few days to make that determination. Unprofessional conduct, which is used in the statute and the regulations, is conduct that's contrary to the standards of the profession. Another example of a definition that's drawn from elsewhere. A pattern arises regardless of whether complaints are minor or non-minor. So the regulations refer to minor complaints and non-minor complaints and provide for different treatment depending upon which category they fall into. But the regulations say when you see a pattern, that should be referred to the commission. And so the idea is that a pattern can arise even if it's based on minor complaints, and then it would need to be reported, and the report should describe what the pattern is. This says ban, should say and provide information on each complaint. That reporting and investigating obligations by an agency apply without regard to whether conduct was in state or out of state. But they wouldn't apply if the agency already addressed the complaint before the regulations even became effective, or if so much time has passed that any criminal or civil liability would be barred by a statute of limitations. So that's an attempt to offer some guidance on what to do with complaints regarding very old matters. Again, I mentioned that there's a distinction between minor and non-minor matters. So the guidance would also aim to provide some clarification on that. And where it refers to basic work rule violations as being minor, that would refer to matters related to the internal functioning, not interactions with the public, not handling finances, not ethical code violations. That a matter involving bias, excessive force, or serious bodily injury or death, that would never be a minor matter. And then the guidance goes on to list a series of things that ordinarily would not be considered minor. And it would provide that whether something is a minor or a non-minor matter is not based on guidance that we have put out or will put out regarding submitting disciplinary histories. So any guidance in relation to that is separate. It would also deal the guidance with audio recording of interviews and other proceedings, because we've heard comments and questions about that. It would say that audio recording is the best practice for a number of different reasons. That audio recording of proceedings other than interviews, so in other words, some type of internal hearing, for example, is encouraged. And where the regulations say that it depends on whether it's feasible, something is feasible unless it's impossible or extremely or unreasonably difficult. And that is another thing that's based on definitions found elsewhere. Next, the guidance would deal with reporting serious bodily injuries and officer-involved injuries or deaths. This is an area that we're going to be tackling in greater depth in the future, but for now, this would provide that agency policies shall provide for those things to be reported to the commission. The regulations call for them to be reported, so this clarifies that we mean reporting to the commission in addition to reporting within the agency. The guidance also deals with the timing requirements found in various statutes and regulations. It basically collects them all because there are a number of different provisions and they all interact with each other, shows how they impact each other, and arranges deadlines chronologically to make it all easier to navigate. Then it also deals with the scope of provisions regarding confidentiality of agency and commission proceedings. And what it states is that the regulations do not bar law enforcement agencies from sharing information with prosecutors, even though there are confidentiality provisions, and it doesn't bar prosecutors from sharing information with defendants or using that information in criminal matters that they're handling. But that prosecutors are asked to consider seeking confidentiality orders or agreements where appropriate. And that in other instances, the recipients of confidential information are asked to maintain the confidentiality. Then it would also address the commission's own handling of complaints. So again, most of it deals with agencies, but it provides some clarification in this area too, because we've gotten questions about that. So it would say that any complaint can be submitted directly to the commission, and that the commission may forward that complaint to a law enforcement agency or address it itself in any way that it deems fit, and that the commission is not bound by agency determinations regarding complaints. It can always make its own determinations. So again, we invite feedback from inside the commission and members of the public, and we expect that this will be placed before the commission again at a future meeting. So if there are any questions or comments that the chair would like me to entertain, I can do so.
I think I see a question from Commissioner Ellison.
Yeah, it's not a question, a comment. Randy, I just want to say thank you for your report, but also, I bump into Randy quite often at the training that I'm required to still as a law enforcement officer. So I just want to acknowledge your team for being out there, actually seeing what it is that we're actually being tasked with. So I commend you for being on the ground doing that, you and your team. Just wanted to acknowledge that.
Thank you, Commissioner. Appreciate it.
Any other questions or comments? Don't think I see any hands in the air, Randy. Thank you as well. Anything further, Randy?
Not on that topic. Again, though, if people have comments, they can submit them to us using an address that's on the website. And we will give consideration to any of that in determining how to develop the best possible guidance that's most helpful to people. The next topic, if the chair would like me to proceed, would be, thank you, a recap of the recent public hearing that was held. Excuse me, that was held last Tuesday, June 6th. And the hearing concerned two sets of regulations. One was 555 CMR 9, which is proposed, and the commission has initially approved, but they have not been finally promulgated yet. That was the hearing process is an important part of the process. But that set of regulations concerns initial certification of officers and initial or renewed certification of independently applying officers, including constables. And the hearing was also on 555 CMR 11, again, a proposed set of regulations that would concern regulatory action and advisory opinions. There were about 100 participants, I think, or viewers on the Zoom. About 15 people spoke. We received about 5 or 6 written comments, but there were also some comments in the chat on the Zoom. And then there were some people who didn't want to speak, but registered an opinion. No one spoke about 555 CMR 11, dealing with regulatory action and advisory opinions. And I don't believe that anyone spoke about the aspects of 555 CMR 9 that concerned initial certification and things other than the regulation of constables. So I believe that all the comments dealt with the parts of 9 that deal with constables in particular. One person supported 555 CMR 9 and focused on the fact that, as he said, the reality is that when constables are out there exercising arrest powers, they should be required to meet the same standards as anyone else who is exercising arrest powers. But I believe all or nearly all other commenters were opposed to this regulation, and really the constable provisions of the regulation. They lodged a number of different criticisms. And so I will go over, in summary, their comments. I think one category was that there were questions raised about the commission's power to adopt such regulations. One comment was that the only time that a constable comes under the provisions of the post law is when making an arrest for any reason and not at any other time or in any other circumstance. I'll talk more about that in a bit. And then there were comments to the effect that where constables are elected, they report to the public and the voters. So that's who they should be answerable to. And there could be constitutional issues such as a separation of powers issue with the post commission setting additional requirements for those elected constables. Another category focused on this idea that that constables, as a result of the enactment of Chapter 6E, and as expected in the draft regulations, excuse me, would not be able to serve civil process, and that in fact they haven't been doing so, and that this wouldn't let them do so. And I'll talk more about that in a bit as well. But first, I'll just note that excuse me, the things that they said in support of that were that service of civil process is important for people to obtain relief, like collecting on debts or judgments and in domestic matters, and that it's an important part of the judicial system. There was some opposition to substantively to provisions imposed on constables regarding the power of arrest. Some people said it's rare for constables to arrest somebody, but they would like to have that power, and but yet should not have to fulfill the same requirements as law enforcement officers, because, excuse me, as police officers, because the skill set is different, the duties are different. One person said that lately they're getting assaulted more, and now they're being told they can no longer defend themselves. I don't know who that commenter perceived was telling people that. I don't know where that is grounded in, but that was the comment. In the definition of arrest within the draft, the last line provides that in addition to other things, an exercise of the powers of constable that's facilitated by the use or display of a weapon is something that would constitute an arrest. And so one commenter said that constables generally don't carry weapons, so that should be cut. There were a few practical considerations raised. So for example, people said that few would willingly accept the responsibilities of serving as a supervisor for a constable, and that the draft regulations don't account for where a municipal official would decline to do so, and that a supervisor who's a police officer might know nothing about constables, that opportunities for training have been insufficient, and that should be resolved first, that few will apply for certification under these new rules, and that as a result, people will be forced to rely on sheriffs who don't necessarily have the resources and don't make services quickly. And then finally, there were people who said that constables, the group of constables now serve with honor, they serve without incident. And there were people who said that we should work more closely with the constable associations and that hearings should be in person and open to the public. There were a couple of things that are larger issues that I'd want to just respond to now and address, because I think it would affect how we proceed going forward. But I see that Commissioner Ellison's hand is raised.
Yeah, just a quick question, Randy, because I was on that Zoom call and it did come up quite a bit about elected constables as to appointed constables. And just a question, are sheriffs, the sheriffs that are elected, are they under the provisions of the post commission? Like, do they have to comply? Not the deputy sheriffs, but the actual sheriffs that are elected for like Suffolk County, Norfolk County. Do they have the police powers?
Sorry, yes, in the what the commission adopted a while back as an interpretation of that part of the statute that defines law enforcement officer and law enforcement agency, the interpretation was basically that the rule with sheriffs would be the same rule that you have with deputy sheriffs and special sheriffs in the statute, where if they're exercising police duties and functions, then they're in scope. If not, then they're out of scope. So that's where that came down. Regarding I'll turn back, like I said, to just a couple of larger issues, because I think I think it's important to address them at the outset of the revision process. So again, one commenter said that the only time a constable comes under the provisions of the post law is when making an arrest for any reason and not at any other time or any other circumstance. So this language about making an arrest for any reason is used in only one place in the statute, and that's in the definition section, section 1, which says that a law enforcement officer or an officer, those terms include a constable executing an arrest for any reason. Now, the commission has essentially proceeded on the belief that if a constable executes an arrest or expects to do so, that person then stays subject to the jurisdiction of the commission, stays in scope thereafter. And so whenever the statute uses the term law enforcement officer or officer, it includes that person. So they're not just subject to regulation at the moment of making an arrest, but at points thereafter. But under the interpretation that's been suggested, basically you would, for that to work, you would have to conclude that that definition really only extends to a constable while executing an arrest and not otherwise. So that's really the only way to get to the conclusion that was offered. So then it comes down to which interpretation is right. What did the legislature intend? And courts will look at, when they interpret a statute, they'll look at what the legislature, try to divine what the legislature intended by looking at the statute as a whole, looking at the surrounding context, considering the problem or the issue that the legislature was trying to address, and trying to avoid interpretations that would lead to absurd or illogical results. So with that in mind, I just wanted to pick out one part of the statute. It's section 10A, but it's an important part because it deals with instances in which the commission is required to decertify somebody So no discretion in the most severe consequence after there's been a hearing and there've been findings made in certain instances based on certain conduct. And so what you see in there is that there's a lot of things listed that could occur or would occur separate from an arrest. Conviction of a felony, submitting false timesheets, knowingly filing a written police report, tampering with a record, engaging in conduct that would constitute a hate crime, engaging in the intimidation of a witness, failing to intervene when somebody else is using excessive force. So then the question becomes, with those things, where the legislature provided that if a police officer arrested somebody yesterday, and today they're not arresting anybody, but they engaged in one of those forms of conduct, if the commission finds that they did engage in those conduct, that police officer has to be decertified. They have to be permanently barred from law enforcement because those forms of conduct are so serious. So the question is, did the legislature intend that if a constable arrested somebody yesterday, but today they're not arresting anybody, but they did engage in one of those forms of conduct, just wasn't related to an arrest, that there would be no decertification, this provision would have no application to them? Or did the legislature most likely intend that in that situation, the constable, just like the police officer who executed an arrest yesterday, but not today, but today engaged in a hate crime, for example, that was not connected to an arrest, that person also needs to be decertified? So that's the question for the commission. And, again, I think so far the commission has taken the view that, and it could re-examine this, but so far the commission has taken the view that, no, that person, that constable who executed the arrest yesterday would be subject to the same consequences, even if they engaged in something on that list while not executing an arrest. And then just the next issue I wanted to highlight is, again, this issue that constables have not been able to and would not be able to simply serve civil process. So in the sense of just delivering documents without making an arrest. That was a recurring theme in the hearing. And quite honestly, I just don't know where that comes from. I don't know why people have that interpretation, where that message is coming from. I don't believe that the commission has ever put out that message that if a constable is just serving the papers, but not making any arrest, that's now prohibited. So I just, again, that's something that, and if I wanted to see if the chair wants, if there are any questions or comments regarding any of this, I'm happy to entertain them. I think, Madam Chair, I think you're on mute. Thank you.
Yes. Commissioner West, please.
Thank you, Randy, and thank you for all of that. That's really helpful. In regard to your last comment about the notion that a constable then couldn't serve process if they didn't have the power to arrest, seems absurd to me, because those types of interactions between people happen every day. But in regard to raising the issue of what the legislature intended with this, I think what they intended broadly was to provide some sort of guidance and support for the interactions between police officers, and in this case, constables, who have this authority to intervene and seize a person in public like no other public employee. So if a constable has the power to arrest, I don't see why they are not susceptible to the post regulations. To me, they are exercising an incredibly powerful position in interactions with the public. And what I've heard in regard to the comments that were made at the public hearing, I wasn't there, don't change my mind in regard to whether they should be under the scope of posts. I believe they should if they have the power to arrest.
Commissioner Wynn?
Thank you. I did sit through some of the public hearing and I left that hearing more confused than when we started working on these regulations. And Randy, I think, from my perspective, what I heard from the constables is this question of serving the writ without actually physically apprehending someone. And I don't know what that process looks like. I've never served a arrest warrant on somebody without taking them into physical custody. But to hear the constables, it almost sounded like they were handing somebody a piece of paper and telling them to go to court, which I don't know how that process works. But an arrest is an arrest. So I agree with Commissioner West. If they're arresting people, they need to be certified.
Commissioner Bluestone?
Yes, thanks. I concur with Commissioner Wynn that I also find myself quite confused after listening to the comments at the hearing. And I think the sense that I got was that there's a lot of variation across the state in terms of the types of functions that constables are performing and how they view it. I think for me, the question that I was most focused on was some of the logistical concerns that the constables had, specifically the issue of supervision. And it does sound like logistically that is a difficult arrangement for them to find a supervisor. And so my question about that, just for us to consider, is what are we looking for with supervision? Because in my profession, supervision implies legal responsibility for someone else's work. And I'm wondering if we're really looking for supervision or we're looking more for a reporting expectation or a consultation requirement or a review of any incident in which they are actually involved in making an arrest. So that would be my question.
Commissioner Kazarosian?
Thank you. I'm just following up on something that Commissioner Wynn had said at the end about the serving the writ, but no arrest. Are they sort of dealing? It almost sounds like they're doing this like they're serving a summons to appear in court. Is that what they were talking about? Because I wasn't at the public hearing, but that just makes no sense to me.
That appeared to be how they were described it. That
Okay.
they had a court order, but they weren't physically apprehending the subject.
But the order says to physically apprehend,
And
basically.
the way I understood it is they, at that point, would say, you have to come with me to the court.
Okay. Interesting.
Commissioner Ellison?
Just on Commissioner Bluestone's comments there on the supervision, it would be very difficult because they all act as independent agents for the most part. So trying to find someone that could, supervise all of these independent agents would just be impossible to do. And I concur with Commissioner West and Wynn in that, you can't have it both ways. You can't have arrest powers, but not conform with everyone else who has arrest powers in how they operate.
Thank you. Any other questions or comments? I guess the only, if I might just add a question, and I address this to you, Randy, could we get some clarification before our next meeting, before we address these issues again on the service of process issue? There has to be something in the rules of court or a statute which addresses that particular, aside from 6E, which addresses that question, because my understanding is somewhat different from what has been described here. But I'm certainly open to, some kind of legal description coming from our legal department, which would, I think, help us address that issue.
Thank you.
Anything else at this point? Yes, Enrique, please.
So I would just suggest that given the comments received and even though we believe that we addressed through the regulations a lot of what the comments provided, that it's incumbent upon us to go back and look through it again with these comments and come back to the commission, perhaps with a revised version or revised update on the regulations before promulgating. In other words, we would not be voting on them or taking any steps to promulgate at this time.
Thank you. And not seeing any other hands in the air, if we may move on. And this really is a bittersweet moment for all of us. Enrique, please.
Thank you, Madam Chair. You are perhaps alluding to the next item on the agenda, which is a
I am.
presentation of a certificate of appreciation. Given that we have two commissioners today this is the last meeting that they're attending. So I'm going to share my screen and present that. You give me a moment. And then can everybody see this? I hope. And I just wanted to read into the record that on today, the 15th day of June of 2023, the Peace Officer Standards and Training Commission presents to Commissioner Kimberly West the certificate of appreciation in grateful appreciation for her distinguished service to the Peace Officer Standards and Training Commission and the Commonwealth of Massachusetts. As a founding member of the Post Commission, Commissioner West was instrumental in the implementation of the multifaceted police reform law while simultaneously guiding the formation of a new public agency. A person of character and integrity with decades of legal experience, furthering the public interest and advocating for justice for those affected by wrongdoing, she brought her extensive legal and managerial expertise to the Post Commission. Post extends its heartfelt gratitude for her contributions, consummate professionalism, and admirable dedication to public service. And given that we have two, I'm just going to go ahead and read the same, a similar certificate of appreciation. There's similarities, but important differences as well. On today, the 15th of June of 2023, the Peace Officer Standards and Training Commission proudly presents the certificate of appreciation to Michael Wynn in grateful appreciation for his distinguished service to the Peace Officer Standards and Training Commission and the Commonwealth of Massachusetts. As a founding member of the Post Commission, Commissioner Wynn was instrumental in the implementation of the multifaceted police reform law, while simultaneously guiding the formation of a new public agency. A person of character, integrity, and decades-long experience and perspective from law enforcement, he advocated for sensible ways to implement the law while balancing the burden of compliance for agencies. He developed positive relationships with the organization and served as a key liaison with the law enforcement community and other stakeholders within the Commonwealth. Post extends its heartfelt gratitude for his contributions, consummate professionalism, and admirable dedication to public service. I will say that this is being done virtually, but they both will receive a framed version of this certificate that we hope they take them where they go next.
Thank you, Enrique. Let me, at this point, if I may, turn to Commissioner West and ask her whether she has anything to say in response.
Oh, yes. Thank you so much, Enrique. How lovely. And I am so honored to be part of this agency. The importance of this agency cannot be overstated. Our law enforcement officers need clear guidance and support. And in my view, the public deserves the absolute best. I think it would be important to know that, as you said, building an agency from the ground up is no easy feat. And I give direct credit to Chair Hinkle, to you, Enrique, and to Randy for your profound dedication and commitment for the success that we have already had. And I will be looking on from afar and enjoying the success that I know you will have in the future. Thank you so much.
Thank you, Commissioner.
And Commissioner Wynn, please.
Thank you, and thank you for that recognition. I reiterate and restate that everything that Commissioner West said, it has been an absolute honor and privilege to have been engaged in this work. And while I am looking forward to turning the page and moving on to the next chapter, if I have any professional regret, it's that I'm not going to be able to continue this important work on behalf of the Commonwealth. It's been amazing to see the progress in building this organization in a fairly short period of time, and the good work that the commission has been able to do, particularly facilitated by the professional staff. So thank you for that.
Thank
And-
you, Commissioner.
Thank you both for your comments. I know I speak for everybody, all of my fellow commissioners in saying how grateful we are for what you have done, how much we regret the fact that you will no longer be part of Post, and we are looking forward to hearing about your next chapters. Let me now, unless there's anything else to address at this point, move on to item number 6 on the agenda. There are no matters not anticipated by the chair at the time of posting that I'm aware of. And so at this point, turning to item number 7, in accordance with Mass General Laws, Chapter 38, Section 21A5, in anticipation of discussion regarding the investigation of charges of criminal misconduct, and Chapter 38, Section 21A7, combined with Chapter 6E, Section 8C and 2, and to the extent that they may be applicable, Chapter 6, Sections 168 and 178, in anticipation of discussion regarding the initiation of preliminary inquiries and initial staff review relating to those, and regarding certain criminal offender record information, we will convene an executive session. And we will do that after this meeting. We will not, to members of the public, we will not be returning to any portion of the public meeting. And I think with that, I would invite a motion to adjourn the public meeting.
So moved.
Second,
And may I ask for a vote on that, please, Commissioner Bluestone,
Yes.
Mr. Calderon,
Yes.
Commissioner Ellison,
Yes.
Commissioner Casarosian,
Yes.
Luma,
Yes.
Commissioner West,
Yes.
Commissioner Wynn.
yes.
I also agree. And with that, our public meeting is concluded. We will reconvene in the executive session in approximately 10 minutes. Thank you very much.